Hello, 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 hello.
Hot mic. Good morning. The District Court of Appeal of the State of Florida in and for the Second District is now in session. The Honorable Edward C. LaRose, Judge presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court.
Good morning and welcome to this session of the Second District Court of Appeal. We have a pretty full docket this morning. Each side will have a total of 20 minutes to present their argument. If you are the appellant and wish to reserve up to 5 minutes for rebuttal, please let me know and we will accommodate you. Our first case on the docket this morning is Collins versus Wadud. I hope I pronounced that correctly. Okay, everyone is here. Very well. Mr. Mayor, you are up.
Thank you. Good morning, Your Honors, and may it please the court. My name is Eric Mayer. I represent the appellant, Daniel Collins. I would like to reserve 5 minutes for rebuttal, please. Your Honors, this appeal presents a rather straightforward issue of the interplay between substantive law and rules of procedure. The substantive law that is at issue in this case is the law set forth in Florida Statute 61.30 and further discussed in the Supreme Court's opinion in Finley versus Scott. And that is the law that governs the parties' respective child support obligations, and in particular, the statutory criteria used to evaluate whether it is appropriate to deviate from the child support guidelines. The procedural rule at issue in this case is set forth in Rule 12.491 of the Florida Family Law Rules of Procedure and further discussed in the Florida Supreme Court's opinion in Gregory versus Rice. That is the set of procedural rules that govern the duties of a child support hearing officer and a circuit court judge when a child support matter is assigned to a hearing officer. Identifying the source of the operative substantive law and the source of the applicable, procedural rules is critical because Article 5, Section 2A of the Florida Constitution vests the Florida Supreme Court with exclusive...
So we've read your briefs. I know I'm echoing the trial court's questions at the hearing, but I think you might want to start there for my purposes, at least. Where did the magistrate go wrong? And first, right, because you're making two separate arguments. The magistrate failed to follow 6130 and the rule, and then the trial court went wrong as well. So where did starting with where the trial court was going, what provision of 6130, the rule, or Finley was not met by the general magistrate's order? What findings were not? There's a lot of findings in there. Would you agree there's a lot of findings?
I would agree there's the recitation of evidence, and there's some findings, mostly the recitation of evidence, but what findings are not there, Your Honor, what's not there is what those findings do is the findings would explain or justify why the prior child support amount of $742 is no longer appropriate or no longer sufficient. But that wasn't an issue in the case. The issue wasn't whether that amount should be modified. There was no question that it was going to be modified. The question was whether the...
Why? Because the 15% in subsection B, or...
Well, because of that, and because because of the change in the guideline amount, yes, would essentially mean a change in circumstances, but nobody argued that there wasn't a change in circumstances or that the amount shouldn't be changed. The argument was whether the guideline amount in excess of $5,000 should be awarded as child support.
Well, presumptively it should, right?
Yes, that is the presumptive. That is the presumptive amount, and if presumption obviously meant, irrebuttable, then we wouldn't have gone to a full day hearing before the hearing officer. But what Finley tells us is that if a party seeks a deviation, then, you know, that party has the burden to rebut that presumption, but there are specific statutory criteria that the judge, well, that the judge must consider in determining whether or not.
In 1A, 6131A.
Correct.
So needs of the child, there's all sorts of stuff about the needs of the child, increased rent, etc. Age of the child, station in life, and then it's the station in life, standard of living, and financial status of ability of each parent. Is there something else?
Those things were addressed, but no findings were made as to where does that leave us? There was no finding that was made, or even a conclusion by the magistrate. The hearing officer that that $5,173, and I'm sure I'm butchering the exact number, was not, inappropriate or unjust.
So that sounds like you just
Simply
reversed the
was-
burden. You said that you sounds like you just reversed it. You said wasn't unjust or inappropriate. When findings, written findings requirement 6130 is if if you want to deviate, you have to show why it would be unjust to have the higher amount, right?
Correct. The burden is on was on the appellant, but the point is there was no finding made that would. I mean, I don't think the magistrate judge even said the burden. The burden wasn't rebutted. The magistrate judge just recited various things, but didn't indicate why that amount, why it was rejecting the argument that this was that this amount was unjust. I mean, all it did, the entire recommended order is just talking about things as to why $740 is no longer sufficient, but it doesn't, regardless of the burden of proof, there needs to be some discussion of what amount would be appropriate.
So I see the distinction you're saying. Okay, so you're saying whether or not it was unjust for the individual with the higher income to pay that disproportionate share. Okay, so but before you get there, real quick, I'm just curious. So you have to contend with the argument that there need not be any written findings under 6130 unless there's a deviation. The findings are if the court did deviate, which court didn't. And you're saying, my understanding is that the rule, because the rule requires findings, that somehow makes it a higher. I mean, in other words, a magistrate has to have more robust findings, or there's a requirement of findings that wouldn't obtain if this were a trial court making the determination. Is that right?
Correct. If the trial court had conducted this hearing, then and the trial court concluded that no deviation was appropriate, the trial court wouldn't be required to make written findings.
Okay, so we're in E. So we're in 124091-4, right? Is that where you're talking about? It says the order must set forth findings.
I'm talking
So
about.
you're saying those findings have to be consistent with Finley and 6130.
I'm saying those.
We're back to those criteria in 6130. Tell me why, if we buy your argument that there's a requirement placed upon a magistrate judge that would not be placed on a circuit judge to it in scenarios in which there was no deviation exceeding 5%. If that requirement exists, for the sake of discussion, what aspects of 6130 were not included in the findings in the magistrate's order?
Well, the reason that there is that requirement for a hearing officer that wouldn't be required if the trial judge himself had done the hearing is because Rule 12.491 requires it. So what now? The trial judge said, "Well, I'm looking at 61.30 in Finley, and it says that it's not required." But the fact is, Finley 61.30 is a substantive law enacted by the legislature, And 12.491 are the rules of procedure that the Supreme Court has enacted. And on the Florida Constitution is the Supreme Court that makes the rules of procedure. And to the extent that a substantive law has some incidental procedural aspect to it that conflicts with a rule promulgated by the Supreme Court, it's not valid. But putting that aside, Finley doesn't say, and 61.30 doesn't say you don't have to make written findings unless you deviate. It says
Well,
you have to
6130 arguably says that.
it says what it says is you have to make written findings if you deviate, and there's no other requirement. So there's nothing that even conflicts with what 12.491 requires of a hearing officer, which is that the hearing officer must make written findings. So there's essentially what the trial judge did was said, well, the hearing officer will, I'll just, whatever I would be required to do, she would be required to do. And she found that, she concluded that.
But I'm asking, I'm asking you, if presuming that there is a higher burden on the general magistrate, how did that general magistrate fail? And by what procedural or substantive law must we judge the general magistrate's findings? I'm looking at 6130. Age, needs of the child, that seemed to be in there. Station in life, standard of living, and financial status and ability of each parent. Mother's an art teacher. Mother had to move into a more expensive. There's a lot of detailed findings. Father is an entrepreneur. Father, wanted to deduct his expenses. There was a lot of findings about his income structure itself. What more should we as an appellate court be looking for in a magistrate's order?
Well, so what the trial court needs to look at is whether the findings provided by the hearing officer support the recommendation. So there was nothing in there. What's
the standard of review for that? It sounds like you're making two separate arguments. One argument is procedural, which is insufficient findings were made, and now you're saying it sounds like you're describing a separate analysis, which is presuming that findings were made, whether those findings support the decision of the magistrate in the trial court. What's the standard of review for that?
Well, we're here appealing the trial court. We're not appealing, technically we're appealing what the trial court did or didn't do. And the trial court didn't do what Gregory versus Rice makes very clear that the trial court must do, is review the record. The trial court didn't review the record. The trial court didn't review the findings to determine that they did or didn't support the ultimate conclusion. The trial court erroneously thought that the hearing officer had the same obligations as a trial court would have, and doesn't need to provide any findings to support the recommendation.
So now we're back to the findings. So now since this folds back under your findings argument, tell me why the findings aren't sufficient under what I just described in 6130.
I think it's paragraph 62 to 74 of the order. If you read the findings, that doesn't indicate to you one way or the other whether the $5,000 plus monthly support amount is unjust or inappropriate. All it tells you is that the $742 prior amount is insufficient. So,
but okay, so let me give you an example. The trial court said, I heard your argument about, the child having a modest lifestyle when she lives with you, and she'll have an extravagant lifestyle. And the court said, I didn't buy it. I don't think that makes it unjust. What do you want us to do about it? Is that either, are you saying that's an insufficient finding, or are you saying that finding, that the father's argument about why $5,000 was unjust, was improper, is not supportive of the conclusion of the magistrate? Which are you trying to argue, and what should we do about it on appeal?
I'm saying the magistrate didn't conclude. magistrate didn't conclude what amount, that amount would be appropriate, and didn't make findings that would distinguish between what 3,000 and 5,000. So the magistrate.
Well, the difficulty in all of this is the magistrate found that her rent was $2,600 a month. Your client's seeking a deviation from the guidelines to $3,000 a month. I mean, it's right on the face of it. The expectation is that she can live on $400 a month. I mean, what more needs to be in these findings? The math is real simple. 2,600 rent. Your client wants to pay her 3,000 in child support.
Well, my client, number one, that's not her only source of income, and child, my client isn't obligated.
She makes another 2,600. That finding's in there too. So now she's at 3,000 a month in South Tampa. I mean, how much do we need to know, really?
$5,000.
There was a finding that y'all agreed that both parties agreed that the child needed to stay in South Tampa. That's a finding.
That's a finding, but there's a lot of people that live in South Tampa and they don't get $5,000 a month in child support. That is an excessive amount, and that is the argument that we were making, and that is the argument that the magistrate judge didn't address. But really, the focus is the trial court didn't review the record, didn't review the findings. So
Mr. Mayor,
it may or may not be right or wrong, but the fact is, my
Mr.
client's
Mayor,
entitled to an
excuse me.
Article 5 judge adjudicating his petition. And while there are provisions that allow the judge to get assistance because of make it efficient and burdens on the courts, it doesn't allow the trial judge to completely delegate his authority and his responsibility to a magistrate judge and say, well, the order looks fine to me because I wouldn't have to provide findings. So why should she? I see that.
Mr. Mayor, can you hear me? Yeah, you're into your rebuttal time. You're up to 16 minutes. Use it as you wish.
Okay. If there are no further questions right now, I'd like to reserve the rest of my time.
Very well. Ms. Remington.
Good morning, and may it please the court. I represent the appellee, Sadia Wadud. And Judge Atkinson, you just did a great job of summarizing the entire argument as the trial court understood it, as I understand it. Judge Tibbles, there's a lot of argument here that he did not review the record at all. And that comes from one statement where he says, I don't know how many pages in this record. And that to me says nothing. That to me it's a lot of pages. If you read the transcript, it's very clear that Judge Tibbles reviewed the record. He was familiar with the amount of prior child support. He is familiar with the excess money, that the surplus that Mr. Collins had every month. He went into all of the details, and his view of things was, well, the general magistrate isn't required to make these findings. And while I agree with that assessment, I think that Mr. Collins' argument is, well, how do we know then the general magistrate, or how did the trial court know that the general magistrate basically did its job? Did the general magistrate actually review the evidence? And if you look at all the findings in the recommended order, it's clear that the general magistrate reviewed all of the evidence and said, like Judge Atkinson sort of summarized, I don't buy this argument. And, Mr. Collins' opportunity at that time was to go to the trial court with a motion to vacate, which he did, and provide his own version of what he thinks that the general magistrate missed. And he provided that, and the trial judge, read it and said, I don't agree with you. And so I'm not really sure what's supposed to happen here as far as, what additional findings need to be made. There was, unjust is a pretty big burden, right? There's the two standards. There's, okay, if we're going to deviate by 5% or less, we can do it without findings based on all those factors. But if you're going to go to the next level and do what Mr. Collins was asking for, which is a deviation of more than 5%, then there needs to be a finding that that amount is unjust or inappropriate. And, you know, the general magistrate in her recommended order looked at the evidence and said, I don't see it. You know, you have this subjective belief that $3,000 is the right number, and I don't, you know, that's just not supported by the evidence. And, you know, we've got a legislature who has decided this is the appropriate amount of child support. If you take these two combined net incomes, we believe that this is the amount that would be allocated to a child who was still part of an intact family. And so that amount exists. It's a matter of strong public policy of the state of Florida. And so to overcome that burden is pretty strong. So, you know, you've read the briefs, obviously. You've heard the arguments, and I guess I just leave this open for any questions you might have about it.
Okay, thank you, Ms. Remington.
Sure.
Mr. Mayor, you have
yes.
4 minutes.
Oh, thank you. So I think the record of the proceedings before the trial court, the hearing on the motion to vacate, is very revealing, and that's 20 pages. It's pages 3180 to 3199 of the record. And if you juxtapose what is stated there with what the Supreme Court said in Gregory versus Rice, and what this court said in Hand versus Kushmer, it is obvious that the trial court did not do what the trial court was required to do. Essentially, the argument by the appellee is, what's the harm? That's the statutory presumption anyway. But that was also the case when Finley versus Scott was decided.
Well, you could infer that, and that's perhaps a sound argument. But I think the additional argument is that there was no violation of the trial court's duty as defined in Gregory. In other words, you're making it from that. Opposing counsel said you're placing your argument that the trial court didn't perform an adequate review on his failure to recall the precise amount of pages. So how do you respond to that?
I think it goes far beyond recalling the amount of pages. The trial court said, and in that particular statement, was, I don't know how many pages this record is, findings, but clearly there were findings. There was some sort of evaluation. The general magistrate just didn't say denied. That really reveals that the trial court did not review the record, but knows that there was not only a transcript of some amount of pages, but a recommended order that contains some findings. But
so we don't know his intonation, but
well, we don't know
the trial court's intonation. But he said I could infer different things from that. He's speaking extemporaneously, and he's kind of sounds like me saying there was some form of evaluation, there were some findings. So did you infer the same thing from me, that I didn't read and prepare adequately because I said something similar to what Judge Tibble said?
No, because I believe that wasn't the extent of my conclusion. That my conclusion was that was the extent of discussion of the record. And on the other hand, Judge Tibble said at least 5 times, magistrate judge doesn't have to make findings unless she deviates from the child support guidelines. So, I mean, you know, obviously the trial court's never going to put on the, I don't think ever will put on the in the state in the hearing. I didn't review this record and I stand by it, but that's as close as you're going to get to what is stated in this 20-page hearing transcript, which focused almost entirely on the trial court telling appellant's counsel, show me where Finley versus Scott says that the magistrate judge has to make findings.
So because the hearing focused on a legal issue, we're supposed to presume that there was no factual analysis performed by the trial court in its review of the general magistrate's proceedings?
Because the legal principle espoused by the trial court was there need not be any findings. Yeah, I think that gets you, that creates that inference that the trial court.
But wait a minute, but in the very quotation of the trial court, he says, but clearly there were findings.
But the obligation of the trial judge is not merely to see were there findings made. It's to review the findings, to make sure that they correlate with the recommendation, and it's also to review the record, in the transcript. Now that is such a serious obligation that this court and the Supreme Court have said if there is no transcript, it probably has to listen to the recording. Here, that wasn't necessary because there was a transcript, but the trial judge has to do the job of the trial judge and can use a hearing officer, but ultimately the conclusion has to be the conclusion of the trial judge, and that clearly wasn't the case here. I see my time.
Mr. Mayor, you're going to have to wrap it up, please.
Your Honor, Your Honors, the trial judge did not comply with its obligations under Rule 12.491 and didn't hold the hearing officer to those obligations. The order below should be reversed and remanded back to the trial court for further proceedings. Thank you.
Thank you, Mr. Mayor. Thank you both. We're going to make a quick panel change, and then we will be back with our next case in just a couple of moments. You can exit the floor. Okay, we are back. The next case on the docket is Sanchez versus State. Okay, but we're all here. Ms. Shapiro, is that correct?
Yes,
You have the floor.
thank you. May it please the court. Laura Sapiro on behalf of appellant Ledsu Sanchez. As to ground one, we are going to rely on our briefs, so I want to focus the remainder of my time on the remaining grounds, starting with ground two. So in this case, the state had introduced testimony from an ex-boyfriend of the victim as to a phone call that had occurred where another man had answered the phone and seemed upset and jealous. It's the defense's position that, first of all, there was a lack of foundation as to this phone call. The witness was not able to testify as to who answered the phone. He didn't put on any testimony that he's heard Mr. Sanchez's voice before, or that he recognized the voice as Mr. Sanchez. So there was absolutely no foundation. Therefore, on that ground alone, the call is inadmissible. On top of that, the call was irrelevant. The call occurred 2 to 3 weeks before. There's no evidence that the argument between the alleged victim and Mr. Sanchez involved a discussion of being jealous about the witness or about any other man in this case.
Was this particular piece of evidence made a feature in the trial?
Not during closing argument, but I think that once it's said, the jury hears it and they're hearing basically bad character evidence that the defendant is a jealous man who just
I heard a lot of other evidence, and this is one piece, this is one phone call. It wasn't made a feature of the trial. Why isn't it harmless error?
Well, it's a big part of, it's a part of the case in the sense that it kind of establishes pretty early in the case that this is a jealous man. It's character evidence, it's irrelevant, and there was no need for the evidence, if any.
Well, arguably it shows state of mind, right?
State of mind 2 to 3 weeks before. I mean, if this call had happened 2
Well,
to 3 days
but
before.
jealousy in relationships, I don't think we need evidence to show this, can linger for a while. You know, if that's what this is about, it's about the character of their relationship and the state of his mind.
But the only
See,
evidence
both then and 3 weeks later.
Well, the only evidence about what the argument was about was that he didn't want her to continue being a dancer. So there's no evidence, there were 2 other people who were with them on the car ride home who said that everything was fine. There was no evidence that he was mad about any other guy or anything like that. So it's the defense position that is irrelevant, it's harmful error, and it also had a lack of foundation, most importantly. Unless the court has any other questions about that ground, I'd like to move on to ground 3, the closing argument, improper closing arguments. First of all, I want to look at subground B, which involved the prosecutor misquoting the defendant. And there's really no question that she misquoted him. He very clearly said multiple times he did not point the gun at her head.
But all these points you're about to make, there was no objection to any of them, right? So we are
Correct.
looking at this for fundamental error, correct?
Yes, it would be fundamental error. And I think this is important because this is basically an admission that the prosecutor is arguing it's an admission that he did point the gun at her head. So this is huge. She's saying from the defendant's own mouth that he said these things when he in fact did not. And she says this 4 times during closing argument. She says it twice during the initial argument and twice during rebuttal. And of course, as to rebuttal, the defense has no opportunity to respond to it or to correct it. And I'd point this court to
But every trial judge says before, at the end of closing argument, before they deliberate, that what the attorneys say is not evidence. You are to rely on your own recollection of the evidence. Isn't that true?
Yes, that's true, but
Is that a meaningless instruction?
It's not meaningless, but considering how serious this error was and that it amounts to an admission by the defendant, I don't think that an instruction like that, the bell has already been rung. It can't be unrung. So they're hearing.
He shot her in the forehead, right?
Well, that's the trajectory is in the forehead in a downward trajectory. Yes.
They're taking all of the inferences together. At some point, he pointed the gun at her head.
I don't know that he was pointing it at her head intentionally or pointing it downwards.
That's not what your argument is. Your argument is the prosecutor said he pointed the gun at her face.
That's what the prosecutor said.
In the greater scheme of things, at some point to accomplish the dirty deed, he had to point it at her head. So
not intentionally.
I don't see any fundamental error in there.
Understood. I respectfully disagree. I think that if he was pointing downwards, just holding the gun at a downwards angle, I don't think he's, they make it sound like it's an execution style murder, even though they didn't charge first degree. So I think that it would be fundamental error on that. Moving on to subground C, where it concerns the neighbor's testimony, where he very clearly said that he saw the machete on the floor in the apartment, regardless of whether he owned it or not, that's immaterial. When shown Exhibit 1A of the machete, he confirmed, yes, that's the one I saw. It was in a different position, meaning it was in a different position from the photo than when he saw it. Yet the prosecutor gets up there during rebuttal without the defense having any opportunity to respond to it and says, he actually said, I didn't see it. It wasn't there when I saw it, and this is a clear misstatement of fact. This is mischaracterizing his testimony. It's a figment of the prosecutor's imagination, and it's important in this case because this is the only third-party testimony that corroborates Mr. Sanchez's claim as to the machete. So that, on its own, but also combined with subground B, that would constitute cumulative error and fundamental error. Just leaving the jury with this impression, they're relying on this prosecutor who they're trusting to diligently recite the facts as they happened. And it's just happening, with this the defendant had no chance to rebut this. So the last thing they're hearing is that Mr. Murcia said he didn't see it when that's not true. So unless this court has any questions about B or C, I'll close with ground A, which is the duty to retreat, where the prosecutor argued he didn't leave, he didn't walk away. And I know that the state makes an argument that this is relevant to excusable homicide. However, this is misleading and confusing to the jury, who the main issue that they're looking at is whether this is self-defense. And the state is arguing, well, he didn't leave, he could have left. That's what they're implying. And the jury's going to hear this and think that that's a relevant factor when it's not. And I'll also point out that in the cross of Mr. Sanchez on trial transcript 532, they do question him on this. He says, I was trying to grab the gun just so I could have some way to defend myself. And the prosecutor says, yeah, but you could have left, you could have walked away. So this is in the jury's mind that this is relevant. It goes directly to an important issue in this case.
But the statement was, you could have walked away. It wasn't, you should have walked away.
Well, I think what the prosecutor argued is he didn't leave, he didn't walk away. And then during cross, what it was is you could have left, you could have walked away. I mean,
But again, don't we instruct the jurors to use their common sense? We tell them that. We tell them that at the close of everything and all the arguments, we tell them that they are to use their common sense. And common sense in this situation, I would think, dictates that anyone could or should walk away from this situation.
I mean, I respectfully disagree. I mean, yes, they're to rely on their common sense, but they can't have their common sense outweigh what the law is. And the law is that he did not have to walk away. He didn't have to.
I don't think anybody said that the law requires this or the law requires that.
I think it's a pretty clear implication that it matters, and it does not matter.
Probably does matter, but no one said that the law requires it. You know, they said they could have walked away. Could actually didn't even say should. Should would be more of a coercive legalist, argument. But could, I mean, yeah.
I mean, I respectfully disagree, but I'd like to reserve the remainder of my time for rebuttal.
Carol, thank you. We'll give you 5 minutes for rebuttal, okay?
Thank you.
Mr. Leto.
Good morning. May it please the court. William Leto on behalf of the state of Florida, the appellee in this matter. I will use my time to respond to counsel's arguments unless this court has any specific questions for me. Going on to issue 2, the state believes the trial court did not err by admitting testimony from the victim's ex-boyfriend, and even if the trial court did err, it was harmless. So going back to the trial transcript, the victim's ex-boyfriend initially stated that the victim had called her about a week prior to the incident about a credit card or a bank card. He then testified that he called her back on that same phone number to inform her that that card was ready for her use. Based on just that interaction and that testimony alone, it's fair for the state to believe that this occurred within that week time span. It was at that point that the state asked the ex-boyfriend what the nature of the conversation was like. And at that point, opposing counsel had objected based on hearsay, lack of foundation, and relevance. Once the state explained that they were admitting this or attempting to admit this evidence to get Mr. Sanchez's state of mind at the time, the trial court overruled, stating that it kind of puts it in a better time frame for the story. And at that point, the state went back, and it was then that the ex-boyfriend stated that it was about 2 to 3 weeks prior to the incident that he received that phone call, or that he made that phone call. And at that point, there was no contemporaneous ejection once that information came to light. And again, as Judge Morris pointed out, the state would hold that this is harmless error, if any error at all. They did not make this a feature of the state, did not make this a feature of their case. There was also other testimony presented that kind of went to Sanchez's state of mind. Even that was from Mr. Murcia, who testified that he had heard an argument from Sanchez and the victim that lasted approximately about 15 minutes. That was around 5 or 6 in the morning. Sanchez even himself testified that he and the victim argued prior to the incident. And Mr. Murcia also testified that he had heard the victim and Mr. Sanchez argue about 2 to 3 times prior to this incident. So unless any questions on that, I believe the trial court did not err in allowing that testimony. Moving on to the trial court's, the prosecutor's comments during closing argument. These are reviewed for fundamental error as there were no objections throughout the closing argument. In relation to prosecution making comments that Sanchez pointed the gun at the victim. As Judge Morris, I believe, pointed out, or it may have been Judge LaRose, I apologize. This is just a reasonable inference of the evidence presented at trial. The state presented evidence that the gun was shot, it was fired at a downward angle, and based on the stippling, it was, I guess, estimated within 8 inches of the victim's forehead. There was multiple testimony that the victim was bleeding from her forehead and had a dark circle on her forehead, which would lead us to believe that she was shot in the forehead, as well as a medical examiner testifying to as much. Sanchez himself testified to grabbing the gun to defend himself, and he testified to pulling the trigger to scare her. Based on all that information, it is reasonable to believe that he pointed the gun at her at some point and she was shot in the forehead. In regard to prosecutorial comments that Mr. Murcia did not see the machete inside the efficiency apartment, this testimony between Mr. Murcia and the state was a bit convoluted. He testified initially that he didn't know where the machete was, and that's in the trial transcript on page 51. He then testified that he didn't know if it was his machete. That's at the trial transcript on page 52. And then he testified that he did not recognize the machete when he was shown Defense Exhibit 1A on cross-examination. All this testimony from Mr. Murcia, it's fine. It makes sense that the state would make those comments at closing based on that testimony and the totality of the testimony that they heard. And further, that of course does not rise to the level of fundamental error. And then I believe counsel talked about Sanchez's duty to walk away. Again, prosecution did not state that he had a duty to walk away. I believe in the context of the closing argument, the state was essentially saying that this is not a heat of passion situation. He was not provoked. This wasn't a bang situation. Sanchez, per his own testimony, stated that he approached her and attempted to calm her by grabbing a gun, and then he pulled the trigger to try to scare her. The state is essentially saying the facts that he did not attempt to walk away. He did not attempt to leave and remove himself from that situation. He essentially just escalated it by grabbing a gun and approaching her. And based on all that, where there is no error or harmless error, the state believes there can't be cumulative error. And if this court has no questions, the state would rely on the arguments in its brief and ask this court to affirm Sanchez's convictions and sentence.
Thank you, Mr. Leto.
Thank you.
Ms. Shapiro, your rebuttal. Can't hear you. Are you muted? I can't hear you.
Sorry about that.
Okay, thank you.
So as to the state's argument that there is a reasonable inference that he pointed the gun at the alleged victim's head, I mean, the state can argue that based on the other evidence, but they're not permitted to say the defendant said something that he did not say. There's a huge difference in that. That basically constitutes an admission that did not happen. And the same point for Mr. Murcia, I mean, whether the state was confused by his testimony, and I would point out that there was an interpreter used for this witness, so that might have been caused some of the confusion, but in the end, he very clearly stated he saw it on the floor. There's no way that the prosecutor can say he did not say that, regardless of what his other answers were. And then finally, I would just point this court to the Olenchak case, which is, I believe it's cited in my reply brief. And in that case, the fourth district noted that an error, for example, a misstatement of law, is still prejudicial, even if the court properly instructs the jury and advises that what the attorneys say is not the law. If this court doesn't have any other questions, I would yield my time and ask this court to reverse and remand for a new trial. Thank you.
Very well. Thank you very much. Thank you both. You can leave our virtual courtroom. Okay, and our next case on the docket is First Acceptance Insurance versus Auto Glass America. Good morning, Mr. Calavia.
Good morning, Judge.
Good morning. We're all here. Okay, Mr. Clancy, you have the floor.
Good morning. May it please the court. I'm Joe Clancy. I represent First Acceptance Insurance Company in this appeal. I'd like to reserve 5 minutes of my time for rebuttal.
Okay.
The trial court's order destroys First Acceptance's contractual right to appraisal by requiring it to litigate the amount of loss before it can compel appraisal. The whole purpose of the appraisal process is to avoid litigation over the loss amount, yet that's what the order forces upon First Acceptance.
Can I ask you a question before we get too deep into this? And my question is a jurisdictional question, so that's why I want to kind of ask it early. The Florida Rule of Appellate Procedure 9.130 doesn't appear to authorize an interlocutory appeal from the portion of the trial court's non-final order which denied your motion to dismiss. Do you agree with that?
I acknowledge that the appellate rule we're relying upon permits the right to a review of an order determining the right to appraisal under an insurance contract, and would appear that the motion to dismiss itself is not appealable, but we did appeal the motion to compel appraisal. It was a joint motion. I'm not sure if the court can't, by enforcing the right to appraisal, order the trial court to dismiss the suit, because the policy also contains the legal action against us clause saying there should be no legal action until you comply with the policy. And we would argue that violates the contractual right to appraisal by filing suit. So that would be the argument for the court being able to also dismiss in addition to compelling appraisal.
I don't think there's any support in the case law that says just because one part, we have jurisdiction of one part, we can get the other part we would not otherwise have jurisdiction for. You agree with that?
I would agree, Judge.
Okay, all right. So I'm not 100% clear. It sounds like you're trying to say, though, we can hear both parts of this appeal, and even in spite of those things which you've agreed with me on. So I'm not clear on how you get us there. You tried to articulate it, but I didn't quite frankly follow it.
The argument would be that by enforcing the contractual right to appraisal, it should be reversed and remanded with instructions to enforce the contractual right to appraisal, and that could be enforced through. We argue in the motion to abate and compel to abate the suit, but we'd also argue that in enforcing the appraisal right, it could be a dismissal of the suit. That would be the argument. I understand there's case law indicating that the motion to dismiss portion of the order is not appealable, though.
Okay, thank you.
And I
Can you
note that
clarify
because
for me the basis of your motion to dismiss in the trial court?
the basis is that appraisal was invoked before the lawsuit was filed, and the policy also contains a legal action against us clause saying that there can be no legal action against the insurance company until there's been compliance with the policy, and that includes the appraisal provision. So the basis was they should not have filed suit. The policy requires them to comply with the appraisal provision before they filed suit. And so we asked the court to dismiss as
And that
well
was the
as
basis of your motion in the trial court?
the
I mean,
motion
I'm
to dis-
asking because I thought I had read somewhere that argument, but then when I went back, I couldn't find it.
that was the basis in the
And I'm
motion to
talking about, I couldn't find it in the briefs, but I thought that was the basis of your argument.
correct. I think it would have been contained in the motion to dismiss the amended complaint or in the alternative motion to abate to enforce appraisal.
Okay, and I want to follow up on what Judge Morris was asking about. I mean, I think, you know, we don't have jurisdiction to the extent that your arguments is that the trial court should have dismissed the declaratory judgment action because it wasn't a proper declaratory judgment action. I don't think we could get there jurisdictionally. So, you know, assuming that's correct, where does that leave you?
It leaves us with, again, it was a joint motion to dismiss, or in the alternative, motion to abate to enforce appraisal, which is the motion to compel appraisal. So that leaves us with essentially all the arguments we're making apply to both motions. So I understand if jurisdictionally you can't get there in the motion to dismiss, all these arguments, all the case law we're relying upon, the Progressive versus Hillsborough case, the Glassometics case, it all applies to a motion to compel to enforce the appraisal process.
Well, you know, one of the difficulties I perceive for your position is that if the trial court had looked at this declaratory judgment action and said, oh, this is nonsense. You're just trying to avoid appraisal and I'm going to dismiss it. It's not a proper declaratory judgment action. The trial court has discretion to do that. And I think you cited the gatekeeping case but here the trial court didn't do that. And there is case law, I think both of you have talked about it, that the trial court has discretion on, you know, when there's a declaratory judgment action that implicates the validity of the appraisal provision, trial court has discretion to go ahead and let that be litigated before allowing appraisal. So A, do you think that I'm accurately reciting what the case law says? And B, where does that leave you if I'm correct?
Correct. So it would be reviewed under an abuse of discretion standard. So we acknowledge that would be the standard for reviewing the order in that regard. There's a Supreme Court case, the San Marcos case, which I think the other side relies upon. But there it was a coverage issue where the insurance company had denied coverage on fraud and misrepresentation. And there the court said that the trial court has discretion to determine the order of the coverage issue and appraisal. We don't have a coverage issue. I understand that abusive discretion would still apply, but there are no coverage issues. First Acceptance Insurance Company, they never.
No, I understand that, but I think one of the cases actually involved the validity of the deck action was challenging the validity of the appraisal provision. And the court said, well, because that directly implicates whether or not the appraisal provision is valid, you know, the court has discretion to go ahead and let that be litigated before getting to appraisal.
Sure, but there still have to be a valid argument to actually challenge the appraisal provision. And here there's not. I mean, the trial court ignored.
That brings us back to, doesn't that require us to look at the deck action, the merits of it, or no?
Yes, as part of the gatekeeping function, should look at the merits of the deck action. But more so, the court should look at the binding case law that resolves a lot of the issues that are raised in the deck action. You know, if an appellate court case resolves an issue addressing the deck action, case law says the issue is moot. So if it's resolved by prior case law, they're not allowed, it's an abuse of discretion to allow them to litigate the issues all over again, where there's multiple cases on ripeness, for example, that resolve the issue. So it's abuse of discretion to allow them to litigate things that have been resolved by the appellate courts. And here, the major issue seemed to be one of ripeness. They were arguing that although first acceptance invoked appraisal, the claim was not ripe for appraisal. They made a couple arguments. One, that there was not a sufficient exchange of information, but under well-settled case law, including this court's precedent of Progressive versus Hillsborough, all the insurance company needed to do is show that they made a payment amount for less than the invoice and invoke appraisal. In that case, the Hillsborough case, the court said once Progressive disagreed with Clear Vision on the amount of loss, it could demand appraisal, and the record clearly demonstrates a disagreement over the value of the claim. What was the record? An invoice and a payment less than the invoice amount. The insurance company is not required to explain, debate, discuss the payment. There's also the NCI case that we relied upon, where they said there's no requirement for an exchange of information. That was one of the DEC action issues in their list of issues, that there was an insufficient exchange of information. There, the 5th DCA and NCI said suing for more money is sufficient to show that there is a disagreement over the amount.
Well, I hate to keep interrupting you and the flow of your argument, but for me, the difficulty I'm having is more of a procedural, not going to the merits, because I don't have a quarrel with many of your arguments, but I have a procedural conundrum, and that is, how do I get to them, given the posture of this case? Because as I said, at least one of the cases says that the trial court denied the motion to dismiss the DEC action. And we have a DEC action that's, whether I think it's meritorious or not, it's there, it exists. The trial court didn't dismiss it, and it squarely calls into question the validity of the appraisal. So how do we say, okay, abate, leave that, and go ahead and do appraisal? How procedurally, how do I get, that's a roadblock that I see. So tell me how I get around it. Because I'm sympathetic to, like, this defeats the whole purpose. I get
it. By applying the abuse of discretion standard, I understand that it's, it's a higher standard, an abuse of discretion, but under the case law we relied upon, the trial court clearly abused their discretion. I'd also like to add, this is a little different because they did not stay the breach of contract. So there's a breach of contract count and the DEC action count. So there's irreparable harm by also requiring the insurance company to litigate the breach of contract count as well as the DEC action count, which is a little different from some other cases. But the essential argument from the other side, and what the ruling does, is it forces the insurance company to litigate the payment amount and prove that it's somehow correct under the policy, that the insurance company, as they say, complied with the policy through its payment amount. There's absolutely zero case law supporting that argument, which is why there is an abuse of discretion by allowing them to litigate these issues raised in the complaint. Demand for appraisal is ripe where the post-loss conditions are met. The insurance company has a reasonable opportunity to investigate and adjust the claim, and there is a disagreement regarding the amount of loss. I've already explained, a disagreement over the amount of the loss is shown by a payment less than the invoice amount. The confusion, or where the court,
I'm only speaking for myself, but I agree. It clearly shows there's a disagreement about the amount of loss. I don't have an issue with that. I'm
Okay,
back
I
to
think
procedurally, I feel stuck.
Where the focus of the order, and I think probably the arguments were this argument that the insurance company did not comply with post-loss conditions of the policy, or did not comply with the policy. That's stated in the order itself. There's no evidence that appraisal is ripe or defendant has otherwise complied with its policy of insurance prior to invoking appraisal. And that ruling, that's an abuse of discretion, because the insurance company, all they had to do to comply with the policy was make a payment less than the invoice amount and invoke appraisal. The order cites cases where, in support of the proposition that First Acceptance had to do more to comply with the policy to make the claim right before invoking appraisal. All of the cases relied upon involved the insured's compliance with the policy, not the insurance companies. We point out in our brief, the only case that we found where an appellate court ruled that the insurance company had insufficient compliance with the policy to invoke appraisal was the Ruddlehammer case. And there it was because the insurance company received an estimate from a PA and they invoked appraisal without providing their own estimate, without providing a payment. And so there was no basis for the dispute, unlike we have here. So that's the only case where an insurance company that I'm aware of was found not to need more compliance to invoke appraisal to make the claim right for appraisal. Yet the court and AGA, they rely upon all these cases for where the insured had to do more to comply with the policy before invoking appraisal. So that the order itself is just, it's unencumbered by any legal precedent of supporting it. The cases relied upon don't support their position on the ripeness, on post-loss compliance. And if you go through the issues one by one in the declaratory action, I get it that it's an abusive discretion standard, but there's absolutely, there's not a single argument that it has any merit. They even get into the order whether appraisal was invoked before they filed suit, as if First Acceptance had to prove that to enforce appraisal. But appraisal can be invoked for the first time in litigation, so that's not an issue.
And
Another case,
Mr. Clancy, let me remind you, you are into your rebuttal time. Use your time as you wish.
okay. And so there's an additional argument that the appraiser itself was not impartial, and they wanted to litigate that issue. But as we pointed out, they never even objected to the appraisal. At the hearing, we stated that we can use an alternate appraiser if they have an objection. That's no basis to deny appraisal, which is also in line with this court's own statements in the Hillsborough case, I believe. But I'll reserve the remaining of my time for rebuttal.
Okay, Mr. Clancy, we'll give you 4 minutes for rebuttal, all right?
Thank you, Your Honor.
Mr. Caldevilla.
May it please the court. Good morning, Your Honors. I'm Dave Caldevilla, and I represent the appellee, Auto Glass America. I respectfully submit the trial court did not abuse its discretion or commit any reversible error, and this court should therefore dismiss the portion of the case where there's no jurisdiction to decide and otherwise affirm. I think Judge Morris and Judge Kelly have hit the nail on the head with respect to the jurisdictional issue, which comprises, I would say, 90% of their brief, continuously argues problems with the declaratory relief claim, that they don't think it has merit, etc. But the trial judge found that it states a cause of action. And so if the insurance company thinks that the deck action is without merit, then they should file a motion for summary judgment or a motion for judgment on the pleadings and get past it if that's what they contend. But you can see from the record that they haven't filed such a motion. They also complain that the judge is allowing us to litigate the breach of contract claim. Well, the reason for that is that they haven't filed a legitimate motion to enforce appraisal yet. But all they have to do is file a motion to stay the breach of contract claim. They haven't done that. They're accusing the trial judge, of making an error on a finding that the trial judge never made. So,
excuse me, file what kind of motion addressed to the breach of contract claim?
They could file a motion to sever, to bifurcate, to stay pending the outcome of the deck action. They filed a motion to dismiss this case, or in the alternative to stay the whole case pending appraisal. But they never said, Judge, if you're going to require us to go first on the deck action claim first, would you please stay the breach of contract claim? They never asked the trial judge to do that, and I'll tell you right now, we will stipulate to that if they file such a motion. But you can't come to the appellate court complaining about something the trial court did or didn't do if you didn't first raise it to the trial court in the first instance. And, right out of the box, Mr. Clancy complains that the trial court is compelling first acceptance to litigate the amount of loss. That is just, and he says it twice during his oral argument. He says it throughout the brief. That is wrong. Number one, the order doesn't do that at all. The deck action claim, which the judge says he wants to decide first, doesn't say we want a determination on the amount of loss. There's a dispute as to which limitation of liability or which measure of damages should apply. That's raised in the deck action. And if first acceptance contends that's not a proper issue for declaratory relief, and they should address that at the trial court. As Your Honor said, there's a roadblock on this appeal. Number one, like I said, 90% of their brief complains about the deck action, and without saying that it doesn't state a cause of action, that they attack the merits of it and basically contend it should be dismissed. And there's no jurisdiction for that. Everybody's acknowledged that, including Mr. Clancy. But still, he wants you to attack the declaratory relief claim, which he can't do. Second, the other part of the roadblock is the case law is crystal clear that when a plaintiff files a deck action that says, hey, they're trying to enforce this appraisal provision against me, and I think it's invalid, or I think it needs to be construed in a particular way that they're not construing it, or I don't think it applies, that type of relief is authorized by Chapter 86 of the Florida statutes, and it's allowed to be litigated first. And the trial judge has discretion to decide that first. And it only makes sense that why are you going to throw somebody into an appraisal when the appraisal provision might be unenforceable, or it might be inapplicable, or they might be trying to apply it in a way that's wrong, and then you got to go back to the trial court and have the trial court undo everything. So it makes perfect sense to give the trial court the discretion to do that first. And
Mr. Calavia, with regard to the invocation of appraisal, the letter came from the servicer, not from the insurance company,
so,
right?
A couple of problems with that, Judge. There's
yeah,
no proof it even came. There's no proof that it was mailed. And Mr. Clancy seems to think that he can just file a motion without any supporting evidence. He's going to say that hey, your case should be dismissed because you have to comply whenever we send you an appraisal demand. And then he's not going to prove that he sent the appraisal demand. And then the letter itself, when you read it, it says, hey, I'm not an employee of the insurance company. I'm an employee of somebody else, and I'm going to invoke appraisal. Well, if you got that letter.
I understand that, but I'm really not sympathetic. Just again, speaking for me, I'm unsympathetic to that argument because it's clear the glass company sent an invoice and the insurance company paid less. So it's evident to me that there's a dispute. And then you sue for breach of contract. So I'm not particularly sympathetic to all of that. I don't think that, I think appraisal is designed to, I agree that appraisal with the insurance company's position that it's supposed to be simple. This is supposed to be simple. We don't agree on the amount of loss. So let's go and have an appraisal and have someone else determine it.
And I understand.
Real simple, but for whatever reason, well, I know what reason, but the glass company doesn't want to go to appraisal. So you've successfully blocked it by appending a declaratory judgment action to your breach of contract claim.
We have successfully blocked it. You're absolutely right. And the insurance company, if they don't want deck actions filed against them, they can put in their policy that we're going to have an arbitration provision. And you got to go to arbitration before you litigate this type of an issue. But they didn't do that. And they write, and Judge, I'm sorry, but I understand what you're saying on the amount of loss, but let's get to the issue that Judge Morris raised. And they have a burden to prove that they sent that letter. The law is clear. Just because a letter is in the file doesn't mean that it was actually sent. And they have to prove that they sent that letter. And they can't just walk into court I mean, it says right on the letter that they sent it by certified mail. Well, why didn't they produce return receipts? Why did they put Miss
Didn't
Amy
didn't
Clark?
they not ask for appraisal as part of the lawsuit? Isn't the motion to stay and compel appraisal? So isn't that a
Yeah, they're
request for
allowed to do that.
appraisal?
Yes, but he is.
So what difference does it make about the
The
letter?
difference is, Your Honor, is that Mr. Clancy argued that it's a condition precedent to us to even file the lawsuit. He asked you today to dismiss our case because
So maybe
he
he
didn't
loses
comply with
on
the
that
law.
argument, but he still asked for appraisal within the litigation.
And we've acknowledged that. He can request appraisal once he's complied with post-loss conditions, which I understand you disagree with me on whether or not we have compliance with post-loss conditions and whether it's within the scope of the appraisal provision itself. The appraisal provision itself says that it's it's only to appraise the amount of loss, and this case doesn't involve a dispute over the amount of loss. It involves a dispute over the limitation of liability. But I understand you, Judge Kelly. I know you disagree with me, so I'm not going to sit here and dicker back and forth with you on that.
Well, I'm just one person. I mean, I have the way I see it. I can't speak for my colleagues.
Well, you're a much more important person on that point than I am, but so I'm not going to sit here and debate that with you. My briefs have said my piece on that issue, and I will point to Judge LaRose's decision in the Kennedy versus Slockett case where he appraised interpreted an arbitration provision consistent with what I'm arguing here. But in any event, I think we're kind of beating a dead horse because there's a roadblock in this case, as Judge Kelly has recognized, and that roadblock is insurmountable. And for that reason, I'm just going to go ahead and rely on my briefs and shut up right now, unless your honors have any other questions for me. I appreciate your time, and I request that you dismiss the portion of this case which asks you to review the dismissal order, the portion of the order that dismisses, and I ask you to otherwise affirm. Thank you, your honors.
Thank you, Mr. Calavia. Mr. Clancy, what did I say, 4 minutes?
Yes, Your Honor.
Go ahead.
Thank you. But if this order stands, there is no contractual right to appraisal in Florida. They can make arguments that completely ignore binding case law. They can contort, essentially mischaracterize or misconstrue case law on what an insurance company has to do to compel appraisal, and raise specious arguments like public policy arguments that have been resolved by the court. It's the ruling itself is just completely not based in any law, in any case law. I haven't even heard an attempt by opposing counsel to make that argument here.
I want to stop you just for a minute because I want to see if you agree with it. One point. Do you acknowledge that there is case law that says if there's a declaratory judgment action that squarely raises the issue of the validity of the appraisal provision, that the trial court has the discretion to go forward with the declaratory judgment action and not order appraisal? Do you agree that case law says that?
Yes, discretion. And it's an abuse of discretion. But also here, where is the challenge to the validity of the appraisal provision? I don't believe there is such a challenge. What they argue is that the insurance company has to do more to show that the claim is ripe for appraisal. That's where the abuse of discretion is ignoring binding case law on ripeness, on what an insurance company has to do to make the claim ripe for appraisal. And they're creating new case law now. There's absolutely no case law in Florida that says that an insurance company has to do more to make the claim ripe for appraisal, that they have to prove that their payment amount complies with the policy with limited of liability provisions. They're essentially bad faith allegations. It's turning a breach of contract and a declaratory action into a bad faith suit by litigating the insurance company's compliance with the policy. They even make these statements in the count 2 for the declaratory action where they say the defendant routinely attempts to rely upon its appraisal provision to avoid making proper payments They unlawfully are underpaying the plaintiff to avoid compliance with its policy provisions. These are essentially a bad faith suit. They want to litigate the insurance company's use of the appraisal provision and the policy provisions regarding the payment amount. But how the insurance company arrived at its payment amount is completely irrelevant to the appraisal process. It doesn't matter how they got there, as we explained with the Middleton case and the Enger case. It doesn't matter. I'm sorry.
I just was saying, yeah, the Enger case, right?
Right. So the basis of the dispute doesn't matter. And just because they want to litigate a policy provisions, the limit of loss provision, doesn't mean that they can when the insurance company invoked appraisal. If they can do that, then there is no right to appraisal, because every time the insurance company invokes appraisal, the other side will say, no, we want to litigate how you arrived at your payment amount. That's why it's an abuse of discretion. It guts the appraisal provision by allowing litigation over the amount of the loss. And the appraisal provision, it's the amount of the loss, not the amount of loss under the policy. So how the insurance company arrived at the amounts are irrelevant. The appraisers themselves don't consider the limit of loss provisions. They would only become relevant if, after the appraisal process, then the insurance company reduced the payment by a limit of liability provision. And so that's why it's also an abuse of discretion, because it's allowing them to get advisory opinions that will probably never be needed, because the appraisals will determine the amount of the loss. The insurance company will make the payment, and none of the litigation will have served any purpose. It results in useless litigation.
With that, you'll have to wrap it up, please.
Thank you. So we would ask the court to reverse and remand with instructions to enforce the appraisal provision by ordering appraisal.
Thank you, Mr. Clancy. Thank you, Mr. Caldevillo.
Thank you.
Okay, our next case on the docket is Cedrus Enterprises versus J-Board. Janice, I can see you there. And there seems to be a problem. All right, we are all here. Mr. Arthur, you may proceed.
Thank you, Your Honor. May it please the court. My name is Ethan Arthur. I'm here on behalf of the appellant, Cedrus Enterprises Holdings, SAL.
Can I ask you a question out of the box? I didn't see a fulsome explanation of your views on section 685. Was it 101 and 102? Is there a reason why there was what I perceived to be little focus on that?
I'm sorry, say that last part of your question again.
Is there a reason why there was little focus on that particular statute as I understand it?
Why there was little focus on that particular statute?
685. You seem to be focusing more on the general chapter 48.
So, I mean, we think the trial court erred here under 685, 101, and 102. So look, before I address your question, Judge, let me take a step back and say we briefed that the trial court sort of erred by finding personal jurisdiction without ruling on the insufficient service of process aspect of the motion to dismiss. We're gonna give that particular point up and focus on the personal jurisdiction finding that the trial court made. We think it was error, and we think that we think that, 685, 101, and 102, it requires it's a contract-based basis for personal jurisdiction. And it requires a contract to have a forum selection clause in which the party, agrees to submit to the jurisdiction of a Florida court. And it requires that the forum selection clause not violate the U.S. Constitution. I mean, we think that the trial court's order that found a specific nexus based on the contract provisions at issue here. We think that he erred in that finding, and his finding violates that provision.
Let me ask you a question then on that, because the joinder and consent to the payment agreement, which your client signed,
yes,
says basically the Cedrus joins in and consents to the foregoing agreement and hereby ratifies and confirms the guarantee. So there's a ratification and confirmation of the guarantee, but it also says Cedrus joins in and consents to the foregoing agreement, which is the payment agreement, which contains the forum selection clause for Florida. So, you're going to have to talk me past this, because it looks like they voluntarily signed up for this. Yes, their guarantee has a forum selection clause in Delaware, but this succeeded this, and they clearly joined in and consented to the agreement that identifies Florida as the forum selection.
Thank you, Judge. And so let me walk you through it a little bit, and I'll explain to you why we think that the joinder and consent did not specifically agree to Florida courts, as it says in that forum selection clause. As you noted, right, there's a separate agreement, the guarantee agreement. I know it's in the record at a few places. I have it right here as A80 through 83. It's an agreement between Cedrus and Jabal, and it's a guarantee agreement where, related towards the debts of the non-party. I guess he's a party below, not a party to this appeal, the NES. And as your Honor pointed out, there is a forum selection clause for Delaware in that guarantee agreement. It was signed in 2017. In 2019, a separate agreement was entered into. And if you'd indulge me at the record at 88, it's the beginning of this 2019 agreement. On the first page, the agreement defines customer, right? Customer is Networked Energy Services Corporation, and that is the only entity that it defines as customer.
Which is separate and apart from a guarantor, I think is your point, right?
That is my point. And a few paragraphs down in that wherefore clause on page 88, it specifically references Cedrus as a separate entity, as your Honor points out, the guarantor, and it titles them for further reference in this agreement as Cedrus. And I'm sorry, before I continue, I'd like to reserve 5 minutes for rebuttal. I don't believe I did that. So
who were the drafter of these arguments, of these agreements?
I'm not sure that that's in the record, Judge.
Okay. All right. I just want to know who I'm supposed to construe it against.
Well, okay. We'll get there, right? So
right.
Cedrus is its own entity at page 88. It is not the customer. If you go a little bit further on page on the record 91, this is section 2.6, acknowledgement of the guarantee agreement. This is talking about the agreement that we just discussed from 2017, right? It specifically references the customer, which is the NES entity, separately references Cedrus, which is my client, and Jabal, and all of them acknowledge, right, that the guarantee agreement applies to this particular 2019 agreement, right, and remains enforceable as to this 2019 agreement, memorializes an agreed payment plan based on extended payment conditions of the undisputed amount.
So does the forum selection clause, is it specific as to the customer?
It is specific as to the customer.
Its own language in the form selection clause.
Yes, Your
Says
Honor.
customer only, it says customer.
Customer only. It does not mention,
Okay.
Cedrus. It only mentions the customer. That's at page.
So what do we make of the language then in the joinder and consent to the payment agreement? The sole purpose of the joinder and consent was for Cedrus to sign and basically say, this agreement's out there, we agree with it. So what do we make of the language then where Cedrus joins and consents to the foregoing agreement, which contains a Florida form selection clause?
I think you take this as Cedrus joins this agreement as written, such that where Cedrus is mentioned, it accepts the agreement.
There was a much easier way to do that. I'm just wondering if your client said too much. All they really needed to do is say, my guarantee extends to this new deal by these two parties.
Well, I mean,
It strikes me that they added more language than you think you're sort of arguing that you're sort of ignoring that point.
I don't think we're ignoring it, Judge. I mean, there's nothing in the record that indicates who drafted these agreements, and nor is there any record that indicates some sort of, how these were negotiated or came, how they've came to be. But I'd respectfully submit that the plain language of this joinder and consent doesn't say anything about changing the language in the underlying agreement to include Cedrus as the customer. And it must be understood as joining the 2019 agreement as written, such that if you go back to, section 2.6, that it does kind of say what Your Honor just said, right? That the guarantee agreement, applies to this 2019 agreement. And then
but then what is the language consents to the foregoing agreement mean, as distinguished from hereby ratifying and confirming the guarantee? Because they're doing two things. So if your position is they're only ratifying and confirming the guarantee, then what is this other language mean? Consents to the foregoing agreement.
I think that it's just an additional affirmation that the 2017 agreement applies to this particular payment plan.
I mean, why would a guarantor, as Judge LaRose has correctly pointed out, why would a guarantor be consenting to the foregoing agreement? The guarantor should have only been ratifying and confirming the guarantee.
Well, if there was just a piece of paper that said, Cedrus ratifies and I want to use this language, right? Ratifies and confirms the guarantee agreement and certifies that the same is in full force and effect without anything more, that doesn't necessarily show that the guarantee agreement applies to the new agreement entered into in 2019. And because the trial court looked at this joinder and consent agreement and said, this must somehow change the language customer to, customer and Cedrus, that he rewrote the contract, and we respectfully submit erred. Now I see that I'm over my. Oh no, excuse me.
No, you have another 5 minutes.
Very well, and so I think it's important, if there's an agreement that's been negotiated, it's important that the court doesn't add to it. And it looks like this joinder and consent agreement was signed on the same day as the underlying agreement, and I think it was incorporated by reference into it. So it wouldn't make any sense that somehow this joinder and consent would alter the terms of the agreement that it was joining and consenting to. This is just a plain language of the contract argument. And once you come to the conclusion that I hope you'll come to, that this joinder and consent agreement doesn't change the language of the underlying agreement, then there was really no basis for the trial court to conclude that our client had consented to the jurisdiction of the Florida court, because it frankly did not. If there's no further questions, I yield back the remainder of my time, except for my rebuttal.
Sure, you'll have 5 minutes on rebuttal, so. Ms. Timus, did I pronounce that correctly?
Yes, thank you.
Okay, thank
Good
you.
morning, and may it please the court. My name is Gabriella Timmis, and I represent the appellee, Jabil Inc. This court should affirm the trial court's order because Cedrus relies on a misapplication of the Florida long arm statute. It is telling that Cedrus has not cited to a single case that involves contractual consent to jurisdiction, and particularly under 685-102, as the court pointed out. Because the law does not support its position, Cedrus has converted this straightforward issue into something much more complicated and focused on the language of the guarantee, which
But
again, as
Bobby, before we get to the chapter 685 analysis, we have to try to figure out whether this document basically is a consent to jurisdiction. And I heard Judge Morris taking this for Arthur. Many questions on that. What's your view on that? Because I think we need to resolve that before we get to 685.
absolutely. And I do want to address Judge Morris's point about the broad language of the joiner and consent. Cedrus cannot pick and choose which provisions of the payment agreement it is subject to based on which provisions it likes. As Judge Morris pointed out, it's broad, unqualified, it acknowledges, joins in, and consents to. The trial court was correct to not rewrite the plain language of that joinder and consent. And Mr. Arthur pointed to section 2.6 in the payment agreement, which is an acknowledgement of the ongoing obligations of the guarantor. That actually cuts against Cedrus because, as the court noted, the parties went beyond just that one provision to execute and incorporate a separate joinder and consent that's broad and unqualified.
Is your point that the only thing in the guarantee that changes as a result of the subsequent document is the situs of any lawsuit?
Yes, for purposes of this appeal, yes, Your Honor. Cedrus has not made any other arguments as to other provisions or disputed that the guarantee continues to apply. Additionally, the forum provision is non-exclusive in the guarantee. That also cuts against Cedrus because they agreed, even in the guarantee, which has been superseded by their joinder and consent, they agreed to non-exclusive jurisdiction.
Well, no, I don't see anybody's done a side by side. So I will assume that there is nothing in the new agreement that is inconsistent with the guarantee obligations, save for the forum selection.
That's correct, Your Honor. The payment obligation changed with the 2019 agreement, but otherwise, there's no inconsistency. And to put this in the context of the issue here, which is very straightforward, it's a straightforward collection case. As Mr. Arthur pointed out, the joinder and consent was executed on the same day as the broader payment agreement. Mr. Gaith Mahdi is the manager of both Cedrus and NES. It is undisputed that neither NES nor Cedrus paid Jabil for millions of dollars in products that Jabil supplied, which is what led to this August 2019 agreement. In the agreement, there's an undisputed amount owed to Jabil of over $13 million. The parties freely negotiated, which is the standard under the case law for satisfying due process, freely negotiated this additional incorporated joinder and consent. They went beyond just the acknowledgement that's already included in the payment agreement. Now, Mr. Arthur pointed to the customer language, but that doesn't change the fact that Cedrus, having access to the entire payment agreement, notice of all of its provisions, it could have just said, we consent to section 2.6, which means that the guarantee is ongoing. They went beyond that. the trial court would have erred to change and rewrite the language to limit Cedars' obligations to only 2.6. It would render the joinder and consent illusory. It would rewrite this separate agreement that they've entered into, which is incorporated and made part of the broader payment agreement. And going back to the broader context here, yes, the payment agreement defines NES, the co-defendant, as the customer. But again, this is, as the trial court correctly pointed out, Cedars guarantee the payment obligations. They are managed by the same individual, which is apparent from the record. And this was all a package deal to allow NES and Cedars additional time to pay Jabil the undisputed amounts. They were aware Jabil's a Florida corporation. It's not unreasonable, particularly where Cedars willingly, knowingly, and voluntarily executed this joinder and consent. And if the court has no further questions on that point, because I want to make sure that I address that, I'd like to turn to Section 685-102, because I do want to address that, particularly given the court's question to Mr. Arthur. The trial court correctly determined that Cedars has sufficient minimum contacts pursuant to Florida's long-arm statute and specifically 685-102 and the 5 requirements therein. The payment agreement includes a Florida choice of law provision. There's a provision consenting to jurisdiction. There's more than $250,000 at issue. It doesn't violate the U.S. Constitution, and at least one of the parties is incorporated or a resident of Florida. Now, Mr. Arthur touched on, and this is in their briefing as well, on the due process consideration. What's important is that, again, Cedars does not cite to any case law that involves a contractual consent to jurisdiction, particularly under Florida statute, and the constitutional due process consideration must be viewed in that context. We've cited to cases, Corporate Creations Enterprises, Lieneman, where Florida courts have explicitly held that where parties freely negotiate these types of forum provisions and consent to jurisdiction, it does not offend due process. Cedars has not disputed that. There's nothing in their briefing that contests any of that or that distinguishes those cases. And under Cedars' construction, as I mentioned, their argument is that all it does is reaffirm the guarantee and that it would be unreasonable, unfair to hold them to the provisions of the payment agreement. The alternative is to allow parties to execute broad, unqualified joiners and consents, and then when they don't like a provision, to selectively choose which ones apply to them. And I'd like to briefly touch on one other point that's in Cedars' briefing, which is they spend approximately 9 pages discussing an alternative argument that if the contractual consent to jurisdiction does not apply, Cedars does not have minimum contact with Florida. That's irrelevant. The court does not have to reach that issue. As the court's pointed out, there's a broad joinder and consent, and Mr. Mahdi's declaration, which is attached to the motion to dismiss, does not dispute that they executed the joinder and consent. It discusses traditional analysis of minimum contacts, that they don't do business in Florida, but we're operating under the Florida legislature, very intentional enactment of 685-102, which applies here.
I don't have to have the defendant be present in Florida at under 685. I just need a party. Correct.
That's correct, Your Honor. Yes. Yep. There are 5 requirements. Cedars does not even dispute in their brief. They concede that the payment agreement satisfies 4 of the 5. The one that they do dispute is does not violate the U.S. Constitution under those the offending due process analysis. But as I noted, we've provided case law where the courts have explicitly considered, Florida appellate courts and federal courts have considered this in the context of 685-102. We can't discuss the due process fair notions analysis outside of this statute. And I believe I've addressed the court's questions, Mr. Arthur's points. Does the court have any other questions? Otherwise, we ask that, and I'd like to just touch on, I understand Mr. Arthur said he is not going to argue the first point, which is that the trial court erred by not ruling on service of process before making the minimum contact determination, so I won't get into that. But if there are no further questions, Jabe will ask that the court affirm. Thank you.
Thank you, Ms. Timmons.
All right.
Arthur, 5 minutes rebuttal.
Thank you, Judge. May it please the court. Just a few quick points. Just as a matter of sort of record and fact, that there is a distinction between the 2019 and 2017 agreement. The 2017 agreement expressly calls for the application of Delaware law when applying it, and the 2019 agreement expressly calls for the application of Florida law when applying it. Those two things are inconsistent and were not addressed, you know, in the joinder and consent agreement. It's not clear why one would control over the other if
I don't recall that anybody talked about that in great extent in the brief.
I don't believe it was briefed. It's just responding to the statement that there were no other inconsistencies between those two documents, Your Honor. I take issue with the idea that Cedrus conceded point two of, or conceded all except for one of the elements in the 685-101 and 102 analysis. The second one, this is according to Jet Broadband, I think was cited in both briefs. The second one is that the agreement has to include a provision whereby the non-resident, which would be Cedrus in this context, agrees to submit to the jurisdiction of the courts in Florida. We vehemently, do take issue with that. We think we did not do that at all. Certainly, on the face of the 2019 agreement, we did not. We're not included in the word customer, and so it's real. The plaintiff in the court were relying on this joinder and consent agreement, but it's not. It's not the 2019 agreement itself does not include anything about Cedrus doing that, and we didn't do it with the joinder and consent. And just to touch on freely negotiated and unfair, we do think it would be unfair to hold that Cedrus consented to the jurisdiction of Florida courts in this forum selection clause when it's not expressly stated therein. I mean, I heard Ms. Timmons.
It sort of strikes me that this document is certainly not as particular and specific as the underlying contracts, which suggests to me this may have been something that was slapped together at the last moment to close a bigger deal. But be that as it may, it says what it says.
It says what it says, and we think it says that we agree that Cedrus agrees to the 2019 agreement as written. So if there's not any further questions, the court should reverse and dismiss Cedrus for lack of personal jurisdiction, or reverse with instructions to do the same.
Thank you, Mr. Arthur. Thank you, Ms. Timmons.
Thank you.
Very interesting.
Thank you.
The court will take a 10-minute break before we return to our last case on the docket. We are back and we're ready for our last case on the docket, which is Matute versus Public Supermarkets. You see Mr. Lee.
Morning, Your Honor.
Good morning. There's Mr. Wolf. Joining us. Welcome to both of you. Mr. Lee, you may begin if you wish.
Thank you, Your Honor. As you said, my name is Brian Lee. I represent Lesbian Matute in this appeal. I'd like to reserve 3 minutes of my time for rebuttal, if I could.
Very well.
So this case, as the court knows, comes to it from a summary judgment that was entered by the trial court, where it found that Ms. Matute could not establish constructive notice of the water that was on the floor at Publix. And we believe that that was an error for a couple of reasons. The case law that we've cited and the federal law that I look to, particularly the Garcia case, talks about where what a court looks at when it sees whether there's constructive notice. It starts right from the beginning, where if there's a lack of evidence indicating that there was even a substance there. We don't have that in this case. We know there was. Publix agrees that there was. They said that in their request for admittance that there was. They agree that one of their people or the employees cleaned up the mess right afterwards, and so we know that it was there. The other part of this talks about how the substance ended up on the floor. Well, the camera angles, and I will concede, and I think everyone would concede that they're not great, because we don't have a camera angle that shows the actual floral refrigeration units where this happened, but you can see at least from the side of it when you're looking at it, the slip and fall that occurred. Miss Matute said she fell, and we can also see at least a customer 19 minutes before opening up the refrigerator door and taking out flowers. You can see the customer with flowers later on in some of the other cameras too. And so we have at least circumstantial evidence as to how a substance ended up on the floor. And the trial court, frankly, put that into effect too. We also have evidence of one of the things that you can look at is if there is evidence of the business owners, in this case Publix's, neglect in inspecting its premises. We have a lot of evidence we presented both to the trial court and certainly to this court regarding all of Publix's policies and procedures regarding this particular area. This particular area was specifically called out in some of Publix's procedures as being an area where water would be on the floor. They told their associates to look for it. And it's along with other things like flower petals and things of that sort. But we also have evidence that there is nothing that Publix had as far as any inspections that were done of that floor. We do see in multiple instances, Publix associates walking past the area. But so there certainly is evidence there that they were there to see it, but none of them did anything. Frankly, most of it just kind of went right by. And so we've got multiple in that 19-minute time frame, multiple employees that could have seen the water if they were looking at it. And so the last thing that we have, and this is one of the factors too under the Garcia, is okay, well, what is the subject? What's the condition of it upon discovery? Well, we do know, and I don't think it's disputed, that this was it was a clear substance. It was water. There was no testimony. Miss Matute didn't say that there was track marks and things of that sort. She did call it a puddle of water. There is some obviously discrepancy on that between the parties. Publix wants to say that it was a couple drops of water. We want to say it's a puddle according to her testimony, but evidently there was water there. And so when we look at this case, that's the facts that we have in the case. And the trial court, through its order, said, well, because there was this liquid on the floor that was there for less than 20 minutes, that in and of itself means that constructive notice cannot be proven by Miss Matute.
Go back a moment if
Yes,
you
Your Honor.
would, Mr. Lee.
Sir.
If we accept your statement that there were employees who were in the area,
Mhm.
it strikes me as it's hard to get the distances between where these employees may be and the refrigerated unit. Is that fair?
Sure. I mean, we know the angle that we've mostly used is sort of the sort of back area angle where
Yeah.
you could see like a refrigeration unit there in the sort of middle of it. And you see kind of employees walking through that area. We don't know whether, but we also see, I think, in one of the videos, and again, it's tough to see. I'll concede that, but we do see Miss Matute sort of stumble back into the frame, right, of the video, and so we know that the area where she slipped is at the very least just off of the camera angle that we're talking about. And so when we're looking at employees that are kind of coming through that area, I would I would say that the video has a fair at least inference that we're not talking about a situation where they're 20 feet away, frankly, even 10 feet away. We're talking about that these employees, or at least some of the employees, are getting within feet, whether that's 5 feet, whether that's 6 feet, I don't know. But they're at least within the area, and there's nothing within the any of the Florida law that says that, well, an employee has to be within this amount of feet, or all it says, and this I'm looking really at the Marcotti case, which is a Winn-Dixie case out of the Fifth, and what they say is that it's not so much that employee has to know, meaning that we don't have to prove as a plaintiff that, yeah, absolutely, that employee would have absolutely saw it from the angle that they were doing it. What we have to prove is that that's kind of actual knowledge, right? What we have to prove is that public should have known. And what that means is that they had a legal duty to use reasonable care, to look for and to discover reasonably foreseeable, but not actually known dangerous conditions. That's from the Marcotti case, right? So the Florida law builds in this concept that, look, you're not going to, if we were going to mandate that a plaintiff has to show that an employee would have absolutely seen that when they went by, it's never going to happen, frankly, because I don't know many employees or corporate representatives that are going to say, oh yeah, I absolutely would have saw that, right? What we have to show is that not only they have a duty to do reasonable inspections, they did, we proved that in this case, but that it's reasonably foreseeable that they would have seen it, right? And it's not actually known to them. So we've seen, and part of that deals with whether it was there for a length of time, whether an inspection could have revealed it, or whether they actually do inspections. Is there reasonable inspections that they do? And in this case, we've got evidence that shows not just that there wasn't reasonable inspections, we have evidence to show there wasn't any inspections of this area. And we also have evidence to show that Publix knew that this area in this, oh, I'm sorry, go ahead, Judge.
Question about
I apologize.
inspection. Yeah, it's okay. And I don't mean to interrupt you either, but
No, you're not.
are they required to do inspections?
Yes.
By whom?
They're required under the law to do inspections.
Tell me where in the law it says that.
There's multiple cases that they talk about. Let me look at the inspection. Well, there's cases where they talk about where inspections are part of the claim, the negligence claim that a plaintiff is bringing. Marcotti is specifically talking about that.
So these cases basically have a requirement that someone in these businesses must do regular inspections.
They must do what they call, Marcotti calls it a reasonably diligent search or inspection. That's the wording that Marcotti uses. That wording is
there anything that triggers this inspection? Is there, I mean, in other words, they just have to have people all day checking these floors?
No, I don't think it says all day, Judge. I think, I mean, again, the language that they use in Marcotti and other cases say a reasonably diligent, right? So I guess there is some give and take as to what is reasonably diligent, but I think the reason why the courts have made that not a specific, meaning that you got to do 5 inspections within 5 hours, is because they give room for a jury to be able to determine whether that was reasonable. Right. And so it's not a situation where a judge, and I haven't seen any cases where a judge has been able to say, as a matter of law, that, well, because Publix only did 1 inspection in an hour, I'm finding that was reasonable.
Well, that's kind of my point. And in this case, we have a 19-minute window,
Right.
right? And I don't think anybody, I think it's undisputed, they did not inspect during that 19-minute window.
Mhm.
And it's clear that some Publix employees came sort of to that area. It's not clear to me that they actually traversed that area, but there were a couple of Publix employees that came near it, but didn't notice it, didn't look, didn't pay attention, didn't do anything. So I guess, what I'm scratching my head with is, there's a 19-minute window. There's no precise regimen of inspections that has to occur. So what do we have it to show that their failure to inspect in this 19-minute window was not reasonable?
Sure. So there are cases that I've cited to in my initial brief, which there are courts that have said that anything that they found that at least 15 to 20 minutes to be a sufficient time for a defendant to be charged. This is the wording from it, to be charged with knowledge of the condition and a reasonable time in which to correct it. Right. That's the Winn-Dixie versus Williams case out of the 3rd, the Lynch versus Target out of the 4th. There are other cases that I've cited too as well in the federal realm that talk about that. The federal courts, particularly the Bray case out of the federal court, even talks about it in the sense of kind of against sort of what Florida says, is that there really isn't a time frame. And the Bray case says, Judge Hinkle in that case said that the statute doesn't really establish a grace period. And whereas, Florida courts sort of say that 15 to 20, some others say different minutes. But what Judge Hinkle in that case, I think, goes really to what the question is that he says that a jury could find that if the liquid was on the floor long enough for a passing employee to see it, then the liquid was long enough for the employee to know it was there. And so that's really what we're dealing with when we're talking about whether
But don't
it was
those cases also involve a situation where it is no longer a clear liquid? There's signs that somebody may have schlepped through the water or what have you.
There are cases, yeah, you're correct. I mean, there are cases where there's scuffs and footprints. There's other cases where it's not an actual liquid, but it's actually like an object, like it's a grape, on the floor or part of a grape. But there's nothing in Florida law or federal law that I can see that makes that a difference, because
Well, it's an indicia of how long it has been there.
sure.
And
Yes,
somebody should have
it certainly
noticed.
can be. Yes. And I think and the way that I read the Florida law on that is that if you had something that was there on the floor and you had nothing else to show you potentially how long that could be there, right? You don't know. Then you can look at these things, right? You can look at how big it is. You can look at where it's come from. You can look at, scuff marks and things like you talked about. But what we have in this case, we believe that we've got sufficient evidence to show, or at least to have a reasonable inference, that when that customer took those flowers out of there, that's when that liquid got on the floor. There's nothing else in the video for the time before and after this 19 minutes that would have caused it, right? And so at the very least, even if it was there longer, that's even better for us, right? So at the very least, it was on the floor for 19 minutes. We know it was on the floor because Publix agreed that there was water on the floor. And so that 19-minute span means that we don't have to have that evidence of track marks and things of that sort, because we know that a reasonable inference from the evidence, or frankly, the evidence, is that it was on the floor for 19 minutes. And so when we then go to cases in Florida, even the Florida cases say 15 to 20 minutes, that's long enough for you to have done an inspection and to have found it and implicitly to clean it up. We know that did not happen. And even if the argument is that, well, the employees were in this area versus this area, I still think that does not matter under Florida law because that time frame was sufficient for an employee to discover it. Whether or not someone came through there doesn't really matter in that instance. But we do know that some people did, if that makes sense. So for for multiple reasons, Judge, we think that the evidence was there for us, for the plaintiff. And again, summary judgment is not for us to prove beyond a shadow of a doubt. Um, Summary judgment, it can only be entered if the plaintiff cannot present sufficient evidence that a jury could then use to determine that there was constructive notice on the part of Publix. So we think that we presented enough evidence to do that, Judge. And because that was the reason that the trial court said that summary judgment was warranted, we think that that was an error. If there's no more questions, I'll just reserve the rest of my time for rebuttal, Your Honor.
Okay, we'll give you your 3 minutes on the rebuttal, okay?
Thank you.
Okay, Mr. Wolf, you are up.
Thank you. Good morning, Your Honors. May it please the court. I'm Diane DeWolf for the Appley Public Supermarkets. Your Honor, summary judgment is common and appropriate in slip and fall cases like this one, where there are no genuine issues of material fact and Publix can prove that it's entitled to judgment as a matter of law. So let's take the first part of that. We don't have any disputed issues of material fact. Contrary to what Mr. Lee has said, Publix does not dispute that whether it was a few drops of water or a big puddle of water. Plaintiff disputes that herself. She says in her deposition testimony, it was huge. It was a big puddle of water, like a liter of water poured on the ground. Now, imagine that on a hard floor. It's a whole liter of water. It's huge. It's still clear. There's no footprints. There's no track marks. There's no cart tracks. There's nothing like that.
What about your duty to inspect?
Well, that's the second part.
Well, it may be the second part, but it's the part I really care about.
Right.
The duty to inspect, and coupled with what part of the store are we talking about? We're talking about in the floral section where people are taking flowers out and waters on flowers. So is there a heightened duty to inspect? And normally, and it looks like in this case also, your floral section is near the entry. So not only is it near the entry, it's got people taking flowers in and out of water. So is there a heightened level that Publix has to inspect? A, because it's near the entrance, and B, because water's coming and going from these flowers. And so it's more reasonable to expect you're going to have water on the floor here. That's my question.
Right.
And I want to add one fact to that. And Publix knows it because they put those bags there for people that are buying flowers so you don't drip water.
Correct. And the bags, if you look at the video, you'll see they're near the cut flowers that aren't in the case. So everybody knows that there's always cut flowers on the top shelf of a floral case that come out and drip water everywhere. But let's talk about Garcia, because in the reply brief, they accused us of not trying to distinguish Garcia. And Garcia is the case that talks about these inspections, right? And here's what happened in Garcia. The plaintiff was in a high traffic area. She was moving from the store into the garden center and she slipped and fell in water. That's a high traffic area. So the Walmart employees in that case said this. They said, we have 1 to 3 people who do nothing all day but sweep the floors. We have a policy that says we are supposed to look at these high traffic areas, these active alleys, every 5 minutes. And by the way, I did that. I looked at it every 5 minutes. And so then they turn on the video and they see for over an hour, nobody looked at that area. There was not one Walmart employee that went in there and looked at that area. There was no one who swept. There was no one who did anything. So they said, you violated your internal policy 12 times during that hour because you're supposed to do it every 5 minutes. You didn't do it at all. And they said, wait. Look at this other case. Let's look at King v. Walmart, right? And in King, there was no inspection for 90 minutes. And the court said, no, the policy in King was not to inspect every 5 minutes. The policy in King was to sweep the floor several times a day. And I would point you to Publix internal inspection policies, which are in the record at pages 1207 through 1209. And Publix policies are very, very similar to the policies that were in place in Walmart v. King. Publix is instructed to do these things before the store opens and then throughout the day. Okay, there's no set time that they're supposed to do anything. Now, Publix, right, and plaintiff is also relying on Winn-Dixie v. Marcotti, which is the reasonable person standard case, right? Marcotti says you are not responsible for every square foot of floor every minute of every day. You know, Publix supermarkets, what? They're open 15, 16 hours a day. They're 50,000 square feet. You can't expect.
That raises a question for me. The video suggests that there are at least 3 Publix employees who are close to that area. It's hard to tell how close, but is it unreasonable to infer that one or more of them should have become aware?
Well, again, in all these cases where they say you should have been aware, we have something, we have an employee doing not what they're supposed to be doing, an employee violating a policy, violating a store policy, and we have something that's not clear. I mean, again, I have to go back to, you know, plaintiff saying, 1, it's a liter full of water, and then 2, it came from flower stems, which I mean, a court is expected to see the facts of the light most favorable to the plaintiff, but it's not required to accept facts that are utterly and completely implausible, right? So we cannot, I can't wrap my head around the fact that a liter of water could drop off the stems of one bunch of flowers that were grabbed out of a bucket of water on the top shelf of a closed refrigerated cabinet. But in any case, we don't have any employees violating policy here. So this happened at 3:29. We have an employee supposedly who came by and restocked one of the flower displays right outside the floral department. Didn't walk around to the other side where she originally slipped on drops or a liter of water, depending on which one you believe. Then we have 6 minutes later, we have an employee coming and stalking and inspecting the bread and wine display, right? Which is also not in that same area. We know that no one alerted Publix to any water being on the floor. We have no accusation that Publix caused the water to be on the floor. We have a few drops of very clear water that we have really have no reason to believe that Publix knew it was there. They say, oh, well, it was visible from the customer service counter. Well, you know, I don't know how far away that is, but it looks like it's kind of far. It's not really plausible to believe that the customer service counter could see a few drops of water, 20, 30 feet away on the floor behind,
Yeah, well, my
floral display.
Publix might be configured much differently than your Publix.
Yeah,
Right?
I think they might all be configured a little bit differently. I'm just talking about the what I could see on the video, because the video and the pictures that plaintiffs put into their brief is the camera that's behind the customer service counter,
Right.
Looking that way into the floral department. So, if we had, I'm sorry, did you have? No. If we had, employees not doing what they were supposed to be doing, this isn't Markowitz, right? This isn't 3 employees who were supposed to be watching these elderly people carry their food from the dining hall into their rooms. They were sitting around chatting and a grape was on the floor. They weren't doing what they were supposed to be doing. This isn't Williams-Sonoma, where they had a written policy that if something is spilled on the floor, you stand there. You stand there and you don't leave until it's cleaned up. They didn't do that, right? They went into the back room to get paper towels and someone slipped in it and fell. This isn't Garcia, where they're supposed to inspect every 5 minutes and an hour goes by and not one person is on camera inspecting anything and somebody fell. That's violating their own policy. This is Jennings, same thing. A kid was supposed to sweep at 4 o'clock. He didn't sleep at 4 o'clock and somebody slipped and fell. Here, Publix policy is just like that in Walmart versus King. We're supposed to do things throughout the day several times a day. We can't be responsible for checking everything every 5 minutes, every 10 minutes, even every 19 minutes. There is no way to be on every spot of that floor. Again, I mean, it's not, Publix isn't disputing the size of the water. We know a couple of things. We know that plaintiff changed her story and said it came from water stem. So that, puts in your head that it's much smaller, right? We know that the corporate representative said, I saw them clean it up with a paper towel under their foot. That hardly seems like a liter of water, right? So, regardless, the trial court took everything plaintiff said is true and said, under the facts of this case, you cannot prove constructive notice as a matter of law. I don't think you need to go to tipsy coachman here. We did mention it in our brief, because I guess because of the difference, like if it was a large liter of water, then it obviously didn't come from flower stems. Then we're in Delgado v. Laundromax. We're in Ken's v. Miami-Dade County. We're in McCarthy v. Broward College, right? We're in a big pile of water. It's clear, no footprints, no track marks. Nobody walked through it. Nobody knows how long it was there, because that wouldn't have been there for 19 minutes because that wouldn't have come from flower stems. So we have no idea where it came from. Then that's easy summary judgment. So that's where we mentioned that at the end of our brief, and you can do that because the facts are here and the court did see them, because you have the video and you have plaintiff's deposition testimony where that's what she said. So, Your Honors, if you don't have any more questions, if any case.
Well, I
you
guess,
do.
I feel like all of these statements that you're pointing to, I mean, this boils down to, did Publix behave reasonably? And I'm struggling to understand why, given all of the things you've articulated, that really isn't a classic jury question. Because doesn't this case just boil down to whether they acted reasonably under the circumstances?
Well, I think the argument is do they have constructive notice? One of the ways that you prove that they have constructive notice is if they've deviated from their own policies, and they didn't do that here. They're saying, no, they didn't inspect.
Can't you also establish constructive notice by showing that they didn't conduct reasonable inspections?
Well, I think that would be more like the Greenleaf case. An unreasonable inspection would be, you didn't do the inspection the night before like you're supposed to, and nobody walked outside all day long. Here we've got a 19-minute window, right? We have three.
Yeah, but we've got this flower section, and couldn't a reasonable juror conclude, given Publix's knowledge that this area is prone to having water spills, which they try to prevent by supplying those bags, that this area, if you're over there, you're stocking bread, you're doing whatever, take a look. If you pass through this area, take a look. That would be reasonable to ask Publix to do that. Or maybe, some other part of the store that wouldn't be reasonable, but in this area, maybe that is reasonable. Couldn't a jury conclude that? You're saying no reasonable juror could find that this area should receive more attention?
Well, I think, Your Honor, you're in danger perhaps of creating a bright line rule that 19 minutes is enough time, that anything longer than 19 minutes is a reason.
I didn't say a number of minutes. I said you have employees, when they're in that area, take a look. You're over there stocking bread, turn around, take a look. Look, check out the floral section if you're in the vicinity.
I don't think that there's any evidence that they didn't really look. Employees aren't required to walk around with their head down looking at the floor all the time. And we're talking about a couple of drops of clear liquid that somebody eventually wiped up with a paper towel under their foot. This is a very small area. So, Publix employees are constantly looking, they're constantly checking the floors, but they're not walking down, right? If they're walking down with their head down, then they're in danger of walking into people, of causing more danger, right? And I think in this particular case, we have 3 employees who are doing exactly what they were supposed to be doing, stalking, looking around, doing their jobs. There is nothing here that says, Publix doesn't have a policy that says when you go over and you stock one of these floral displays, or when you stock this bread and wine display, that you have to take a loop around the floral department.
I don't think I suggested that they had a written policy, but I'm talking about what's reasonable under the circumstances and what a reasonable juror could conclude.
Well, Your Honor, again, we've cited, we talked about Garcia, and Garcia distinguishes that case from Williams, and Williams had the same exact, I'm sorry, not Williams, King. Walmart v. King v. Walmart. They distinguish that, and that's exactly what we have here. The King v. Walmart case, they had a policy that they are supposed to sweep throughout the day. That was their policy. And there was evidence that no one had swept in 90 minutes. They didn't find that unreasonable. It's not unreasonable. You can't, and Marcotti says this, you cannot be over every place. And that was a high traffic area in King as well. And you can't expect every single square foot of a 50,000 square foot store to be inspected, every 5 minutes, 10 minutes, not even 19 minutes.
I don't think I suggested every single square foot. I think I framed my question around this particular area that Publix has recognized could be problematic. Just like stores that put plastic bags at the entry for people to slip their umbrellas into, so their umbrellas don't trap water throughout the store. That's an acknowledgement, and we know this could be an issue. We want to try to prevent this kind of event from occurring by, trying to limit the amount of water that ends up on the floor.
And there were, you can see it in the video, there's mats, there's green bags, there's employees that are there stocking shelves. There's very difficult to see a few drops of clear liquid on the floor. And if it was a liter of liquid, as plaintiff initially claimed, and you can also watch the video and see that 14 people walked through. I counted 14, there may be more. In that 19 minutes, 14 customers walk exactly through where plaintiff walks. So if there was a liter, there would have been something there. There's not. Obviously, these drops were so small that those 14 people managed not to step on them, or else they weren't there for 19 minutes. But in any event, no, I don't think a reasonable juror could find that this inspection was not reasonable under these circumstances. I think you'd be in danger of creating a bright line rule. And that is, the King case tells us that an inspection wasn't done for 90 minutes and it wasn't swept for 90 minutes. And that's not unreasonable. Your Honors, I think if any case is appropriate for summary judgment, it's this one. This is a simple case of a few clear drops of water on the floor, and someone fell. And that's just not enough to survive summary judgment. So we ask that you affirm.
Okay, thank you, Mr. Wall. Mr. Lee, we'll give you your 3 minutes.
Yes, Your Honor. Thank you. Hopefully I won't use them, but I'll try not to at least. There's a lot of things that were said there that frankly aren't evidence. There is no evidence that whether it's drops, whether it's a puddle, or that was not able to be seen by anyone. There's no evidence of that. Publix hasn't presented evidence. There is none. There is no evidence that their employees didn't see it. There was not an employee that came in and their testimony is that I went through this area and I saw nothing. There is no evidence about that. What there is evidence of is that Publix has a specific policy for inspecting these flower displays and around them. And it requires their employees to not only inspect the floor, but to inspect it for foreign substances. And we know because of their policy that Publix has up to 10 people that are supposed to be in this section doing this. And so we know that we know that they know it's a problem. We know, and their corporate representative says very specifically that they know that water gets on the floor in that area. They know that their flowers are in these open containers, which are in water. So that's there. And they have zero evidence to say that someone passed through that area and there was nothing there. There is no evidence that says that. And so what we have, and I agree with Judge Kelly, is that when we boil down this case, it was a case of was Publix reasonable in what they did for this flower department? The trial court, did not allow the jury to get to that question, which we believe there was evidence there that a jury can make that decision. And all we're asking here is for this court to allow them to do that. So if there's no other questions, Your Honor, we would ask that this court reverse the trial court's judgment.
Thank you, Mr. Lee. Thank you both. That concludes our topic for this morning. We are adjourned.